Hello and welcome to this masterclass on the business of pro bono. My name is Sarah Morton-Ramwell and I'm the Global Pro Bono Partner at Ashurst. My background is in human rights, particularly gender and reproductive rights. I began my career at the Centre of Reproductive Rights in New York. I then worked at International Planned Parenthood Federation in London. I've worked as a fee earner in a corporate law firm and spent the bulk of my career working full-time in the pro bono practice of commercial law firms. I work for Ashurst, which is a leading international commercial law firm, and I look after their global pro bono practice across 28 offices in 16 countries. Today, I'll be talking about how to set up a pro bono practice and the business case for doing so. So pro bono is defined differently at each firm and in each jurisdiction. I think regardless of the definition of pro bono that you adopt, what's important to remember is pro bono will never be a substitute for a properly funded legal aid system. It's always an addition to a properly funded legal aid system. At Ashurst, we have a global pro bono criteria by which we define pro bono. We see it as an ethical professional responsibility of all lawyers. And our criteria says that pro bono is legal assistance free of charge. And we have three groups in which we would fall under the criteria. The first of which is marginalised and disadvantaged individuals of limited means. The second of which is not-for-profit organisations or social enterprises that really assist the most marginalised and disadvantaged. And thirdly is matters of the public interest or broad community concern. Defining pro bono for your organisation or your firm is a really important first step to creating your pro bono practice. You don't need to reinvent the wheel. There are definitions out there that can really assist you. One that I would recommend that you look at is the TrustLaw definition. They do that for their global index of pro bono, so it'll be on their website. And it goes into really great detail into what is a qualifying fee earner, a qualifying client, and qualifying work. It was done in consultation with professionals in pro bono like myself and many others across the globe. It's a really useful definition because it is wide enough to encompass the different pro bono cultures in different jurisdictions, the different challenges people face in the flow of pro bono work, practically doing pro bono work, and the regulations that affect pro bono work. But at the same time, it sets goalposts on what isn't pro bono. So it's a really good starting point. And then you can decide if you wish to adapt it or make it more narrow to suit your organisation or firm. So once you've got a pro bono definition, the next step is setting up some internal infrastructure to deal with your pro bono practice. This will differ depending on whether you're an organisation or a law firm. Certainly for law firms, I do think best practice is being followed by Ashurst and others by setting it up as a legal practice, which is headed by a full-time pro bono partner and a full team of full-time lawyers. However, that is not always possible, certainly for in-house lawyers and some firms. So I think at a minimum, you really want a senior person, particularly a partner, as well as an associate or a more junior member of the team who is responsible for the pro bono practice. And if these people are doing it not as their full-time roles, it would be good to look into setting up a pro bono committee, which could support them in the decisions about the pro bono practice as the practice develops. So once you have a pro bono definition and you have the internal infrastructure for a pro bono practice, you're going to want to start to find some pro bono projects. To get a regular flow of pro bono work, there's a number of resources that you can use. The first that I would recommend are pro bono brokerages. These are essentially third-party organisations that are not-for-profits themselves. They work with many community groups, not-for-profits and social enterprises, and they create weekly or monthly matter lists they send out to members. Some have membership fees. Others are free. For example, if you don't yet have budget, TrustLaw is an excellent resource. It sends out weekly email lists with many matters in each jurisdiction around the world, which you then bid for. That's a great way to get a real regular flow of pro bono work. After that, though, you might want to start to directly liaise with not-for-profits and social enterprises, particularly in your areas of expertise that you think you can add value to, or areas that you'd like to develop a secondary specialisation, Or they might be in regions in the world you want to start to develop pro bono work. So working directly with them is another step. Also, you can start to involve your employees. So do they have referrals and connections to social enterprises or not-for-profits that they might want to bring to you? Also, your clients, they may also have referrals they might want to send through. Equally, if you're in a jurisdiction where you are able to do access to justice work, legal clinics and working with legal advice centres will be a fantastic way to get your lawyers working with individuals in need directly through a legal clinic. There is a question of pro bono program versus pro bono practice. At Ashurst, we very much see our pro bono practice as a standalone legal practice, to be treated exactly the same as any of our legal practice, to be to the same standard, same levels of supervision, engagement letters and procedures, but it's also treated exactly the same. So all pro bono hours is treated as billable and bonusable for hours targets. And it also has the infrastructure of any legal practice. It's just a bit smaller. So I am a full-time pro bono partner. I have 5 full-time lawyers in Sydney and London to help me with that practice. And I think it's very important to have that message that it is exactly the same, it's treated the same, and it's to the same quality as all your legal practices. Over time, as your pro bono practice develops, you may want to focus on certain areas or develop areas of secondary specialisations. You might want to focus on the skill sets that you have or the global network that you have and where you can really add value to social justice issues. However, you shouldn't be limited by the skill set that your lawyers necessarily have. You can develop what we consider pro bono secondary specialisations. These are often narrow areas of the law where, through adequate training and through supervision by experts in these areas, you can really begin to develop secondary specialisations. In Australia, at Ashurst, for example, we, over time and since 1999, have 3 focus areas. The first of which is rural, regional and remote communities. The second of which is Indigenous communities. And thirdly, it is people affected by cognitive disabilities or their carers. These are the social justice issues we felt that we could add value through our skill sets and through secondary specialisations that really met a vast area of need in Australia. These focus areas are going to be different in each region that you work in. So for example, in Asia, we're starting to develop focus areas on anti-trafficking and anti-slavery and migrant worker rights, because those are the social justice issues that the lawyers locally really want to tap into. So look at the social justice issues regionally or locally to the offices that you are based and have a think about how your skill sets may lend itself to that work, or how you can be trained up to assist in areas you might not have worked in your commercial practice. There's a lot of different matters that can be considered pro bono in your pro bono practice, from law reform to legal advice and legal representation, to legal education and training, to legal research in perhaps rights-based work that you might not form part of your regular practice, to legal secondments in not-for-profit organisations or social enterprises, or legal clinics, so legal advice centre work for individuals, or legal clinics for not-for-profits or social enterprises. The types of work that would not be considered pro bono are things like free legal advice, but to friends and family or for business development reasons. No win, no pay is also not pro bono work, nor is work that you end up writing off or not charging for, but doesn't fit within the pro bono definition or the criteria that you have decided upon. Pro bono is also not non-legal volunteering. Certainly at Ashurst, we have a thriving corporate responsibility program. However, we do see that as quite separate to our pro bono practice, which we see as a standalone legal practice. Firms may want to set internal pro bono targets or sign up to external jurisdictionally based pro bono targets. We found it useful at Ashurst to have an internal target of 52 pro bono hours per fee earner per year. This has been set and approved by the board, which is a wonderful message of top-down support for the pro bono practice. However, firms themselves may want to set their own targets, or they might want to sign up to external targets, which are either average hours per fee earner per year, or a percentage of billable time spent on pro bono. An example is in the UK, there's the Collaborative Plan for Pro Bono, which myself and others helped set up last year. As part of the Collaborative Plan membership, you sign up to an aspirational pro bono target of 25 pro bono hours per fee earner per year, which you report on an annual basis. In Australia, there is also a national target there of 35 hours. And in the US, for example, the Pro Bono Institute has a pro bono challenge where firms can sign up to a percentage of billable time spent on pro bono. They also have a challenge for in-house teams in the US as well. It can be challenging to know what good looks like in pro bono in different jurisdictions. A very helpful tool I found is the TrustLaw Global Index, which they first released in 2014 and is now done on an annual basis. As part of the index, law firms provide information on the average hours per lawyer spent on pro bono in each jurisdiction. This is put together in a table, and it's very helpful then to see what are the results being seen by other law firms, what's the average for, say, France or for the UAE, and really what is best practice in that jurisdiction. Because each jurisdiction has a different culture of pro bono, there are regulatory and practical issues, and so it is hard at this point in time to expect the same level of pro bono engagement across all jurisdictions. However, you might have jurisdictions that, while doing less hours than other jurisdictions, perhaps in the UK, Australia or the US, where there's been quite a good culture of pro bono, they still may be performing at an extremely high level for that culture. It also helps to know who is doing pro bono in these jurisdictions so that you can begin to collaborate with those firms. It's just a very helpful way to understand pro bono in each jurisdiction. So at Ashurst, I run a pro bono practice across 28 offices in 16 countries. To do this, I have a dual strategy. Firstly, I want to develop leading local programs, which really tap into the social justice issues most relevant to that local office, that country or that region, that people care about, that people want to take part in to assist. As a second step, I want to also get cross-border projects that get my offices working together across a region or globally. Because I think as a global organisation, you have responsibilities to try and tackle not just local social justice issues, but the social justice issues that cross borders. An example of that is human trafficking. There's a very strong business case for pro bono, and it might be helpful to articulate it to your organisation or to your firm. The first key area in which the business benefits from having a thriving pro bono practice is in human resources, particularly in recruitment, and particularly for graduate recruitment. Junior lawyers really care about social justice issues, and more they ask about the pro bono practice and will make decisions on where they want to have their career based on these practices. Also, it's very helpful from a retention perspective by keeping and engaging your best lawyers because they are doing interesting and varied work. They're able to give back, but also it's a way of sharing their values and the values of the organisation that they work for, which helps to keep them engaged and to keep them at the firm or organisation. The second key area is the learning and development benefits that you get from by involving in pro bono. From a junior lawyer perspective, particularly working at legal advice centres is hugely beneficial. It puts them outside their comfort zone. You are learning secondary specialisations and you're dealing with individual clients that you might not get that experience at a junior level in your career otherwise. It's also important to talk to your learning and development departments or department heads to see how some of the learning and development needs of those departments could be met through pro bono participation. And the third really important area is, of course, business development. By having a reputation as a leader in pro bono, that is very important. But also working with your commercial clients on pro bono projects is a fantastic way to get to know them, to show shared value, and to add value to that relationship. So when law firms partner with their commercial clients, this can come in any different form, from something like partnering on a pro bono event, particularly in jurisdictions where pro bono cultures are not that strong, inviting more lawyers, inviting local not-for-profits and social enterprises to talk about pro bono and what can be achieved together is a great way to start, right up to projects where you might have in-house lawyers and law firm lawyers working together on a weekly basis at a legal advice clinic, or you could work together on a legal research or a legal advice project, or run an event, legal education training event for not-for-profits and social enterprises is another way. There are many benefits for in-house teams to partner with law firms on pro bono. They may well be in a jurisdiction where they are somewhat prevented from taking on pro bono work themselves. So by partnering, that is taken away as an issue. Also, they may not have the infrastructure that law firms have to really find the most impactful and interesting projects to get involved in. So that's another way that the law firm can add value. Ultimately, I think it's a win-win for everyone. It's helpful for the in-house lawyers to get a regular flow of interesting work. It's wonderful for the law firm because they can add value to really priority relationships. And it's great for the pro bono recipient. It's ultimately about bringing more passionate and highly skilled lawyers to fight for social justice. That brings us to the end of this masterclass. Thank you for watching.